All right. We will go on the record in the matter 24 CF 162, State of Wisconsin versus Jack Fenton. This state appears through District Attorney Kevin Schmidt in person. We have Charlene Perin, defense counsel in person. Mr. Fenton appears by video conferencing in custody in Brunette County Jail. We're set today in this matter for a motion to admit child.
This isn't just another probation check-in. This is Flannery's last shot to prove he can follow court orders. But as you're about to see, he's playing a dangerous game with the judge's patience, and the stakes are about to hit hard.
Audio-visual statements for this case. I have reviewed the motion. I have reviewed the response from the defense. I have also reviewed the confidential flash drive, and I have opened it and signed it and dated it as I am required. Ms. Perin, in your response, you indicated that for the most part, you do not contest having the audio-visual information from the child or children. However, there is a few caveats that you wish to discuss or to argue in front of the court, I believe. You have the floor.
Thank you, Your Honor. Yes, I do think that the officer who did the interviews did a nice job of verifying that the children knew the difference between the...
Pause for a second. He was given clear instructions: void drugs, show accountability, bring proof of work. But already, we're hearing the first cracks in compliance. And remember, judges have memories like elephants.
Truth and a lie. I think that's one important factor that the court has to consider. And so otherwise, upon review of the videos and review of the law, I don't have an objection. I do believe the younger child makes some statements about what other people said, other than the defendant. So I believe those things are hearsay that should be redacted. And I think Mr. Schmidt and I can discuss that and redact those before those are played at trial. And then I believe there's a provision that the prosecution can provide a transcript. Sometimes I've noted during...
Interesting twist. He claims the marijuana wasn't from new use. But here's the legal catch. Probation terms don't play guessing games. If it's in your system, you're in violation. Intent doesn't matter, results do.
During trial, that transcripts are provided to the jury as well. I'm not sure if Mr. Schmidt has determined whether he's going to do that or not, but I would like transcripts of the recordings as well. So I am requesting that.
For the court's scheduling order, it is a directive that if they are going to play a video, they must get a transcript of that video, not from my court reporter, but from another court reporter. My court reporter can do that, but depends on her availability. So it is in the scheduling order, not only for counsel, but for jury as well. Okay. All right, Mr. Schmidt, with a response to Ms. Perin's statements here.
So technically the scheduling order says upon motion, the court can order transcripts. I have no objection to preparing transcripts and providing them to counsel. I would object to giving them to the jury. There's a reason one of the preliminary instructions is transcripts not available to jury. And it cautions heavily against ever doing that with a jury, because if they rely on a transcript instead of their memory, they've already done appealable error. So if Ms. Perin wants them available for us to use, to refer to be able to like cross-examine witnesses, I'm okay with doing that, paying for it and providing it. I don't know if I can provide it if I do it through a court reporter. I think they would have, there's rules to that, I'd have to look into it. I think they have to pay a smaller amount is what the court reporters usually say. But I'm fine with that, just not admitting it to the jury or sending it as evidence. To the hearsay thing, the purpose...
Let's be real. The judge gave him a lifeline in February, no conditional jail. but 2 drug uses and 0 job documentation later. That lifeline is fraying. Fast.
Purpose I want to use the younger child is to corroborate what the victim said to her. That's the sole purpose I'm using it. Since I'm going to be using it after the victim goes first, it's not hearsay, because one of the exclusions of hearsay is someone's statement about what someone else said after they've already testified and been subject to cross-examination, and it's to rebut an implied argument of lying or fabrication. That's in 908.08, I think is the hearsay statute. Let me double check that.
Yes, it is.
Yeah. So because I plan using it afterwards, anything EMA says about DAA, what she said to her, I think will not be hearsay. If there were other people's statements you're concerned about, I don't. If you articulate that to me, we could talk. But yeah.
So when I've been in other trials and there's been transcripts prepared, because sometimes it's difficult to hear everything that specifically children say during their testimony, during a video. Sometimes a jury is provided a transcript while the video is playing.
That's
Not-
exactly my experience, and I've done it half a dozen times in trials.
Not to take back. So thank you. So the other thing is, yes, I was speaking partially to statements other people, the child said about what other people said other than the other alleged victim. But I also think the argument counsel is making is premature and would depend on how evidence comes in and what arguments are made.
I mean, DAA is going to play a video and testify that the defendant sexually assaulted her. The defendant can't not say that's false. Like, that wouldn't be a defense.
Well, you're talking about the victim. I think Ms. Perin is speaking of the sister of the victim.
Right. So
Right.
I guess I don't understand what her argument is.
Her argument is, it all depends on how the trial flows.
I mean, if I do DA first and EMA next, then it's just not hearsay is what I'm saying. Because DA has already testified and been subject to cross-examination.
And I think that's the understanding, but just in case it doesn't, is Ms. Perin's argument.
Well, yes, and if I understand counsel's argument, counsel is saying that it's corroboration of what the alleged victim. It's the younger child is saying that her sister.
Okay, here it comes. The moment of truth. Everything Flannery's done nor not done since February is about to be weighed. This isn't just a hearing anymore, ... It's sentencing time.
Said the same thing to her. And so it's corroboration of what she said. And so if the defense claims that she's lying or something like that, that it's a consistent statement. And so I think part of whether that comes in or not depends on what the cross is of the alleged victim and how her testimony comes in.
All right, I'm understanding her flow. Are you?
I'm understanding what she's saying, but I don't think it makes any sense. Because like I said, the defense isn't going to argue that what DA said is true, that Mr. Fenton sexually assaulted her, which is why 90801 sub 4 sub A sub.
Boom, 90 days jail. The leniency window just slams shut, and his plea, too little, too late. Pro tip, If a judge gives you one chance, don't waste it on meth and paperwork excuses.
2, offered to rebut an express or implied charge against the declarant of fabrication or influence or motive. That's what it's for. I think it's unreasonable to say if the defense doesn't ask a question or doesn't accuse the person of lying in the cross, that I can't offer a statement for that purpose. I think that's going a bit too far. Because no good attorney would just accuse a witness of lying on the stand. That's not how impeachment works.
I'm just not going to respond to that.
Well, the hearsay information is noted. I'm pulling up the statute right now. You said sub 1, sub 2? No.
Sub 4 in 90801, and then sub A, sub 2. That is how statements corroborating other witnesses are introduced in trials, through that sub. And the one above it is how you introduce witnesses to impeach others.
90801 sub 4 A2 states consistent that the declarant testifies at the trial or hearing and is subject to cross-examination concerning the statement, and the statement is consistent with the declarant's testimony and is offered to rebut an express or implied charge against the declarant of recent fabrication or improper influence or motive.
Yeah, so obviously the rules of evidence were not intended to prevent witnesses corroborating other witnesses by saying, hey, they said the same thing to me. That would be an unreasonable view of the hearsay statute.
Well, that is accurate and true. You can't corroborate. So are you asking me to make a ruling right now, or are you asking that this be open to objections determining on how the examination of, I'm just going to say the sister goes, Ms. Perin?
That is, my understanding is that today is about whether the video would get in, and then the ruling on whether, so, we have no objection to that. So whether the video gets in as hearsay is a question that the court would determine depending on how things go at trial. That's my position. Because I don't think the court can make that decision until after the alleged victim testifies. I just don't think it's possible. That's my opinion.
All right. So based upon the stipulation of the parties, the video will be admitted, and the court will wait until the trial to determine if there is an objection, and then the court will rule based upon what has occurred and then the objection made at the time, if any.
So just to clarify then, the only hearsay statement you were alluding to in your letter was EMA saying what DAA told her.
Right. I don't object to the other one at all. The alleged victims.
I just wanted to make
video.
sure, because obviously there's some like, mom said this, dad said this, not really relevant to the case at all. You know what I mean?
Well, I don't know if I believe that's not relevant, but that's what I was speaking
I'm trying to
to.
clarify what you're objecting to.
All right, I'm just hearing, what I'm hearing right now, though, is that they're being admitted, and Ms. Perin will be doing her job at the trial, and if she hears anything she doesn't believe should be admissible and should be in the jury's review and under their consideration during the trial, she will object, and the court will determine at that time whether or not the objection is sustained or overruled.
Yes.
All right. So that could be with any statement made by the parents. It could be any statement made by the sister. Again, I've reviewed the 2 interviews, and I believe there were statements of the parents. I can't recall off the top of my head exactly what they were stating, when and why and how. So that's where we are with that, with the video. It is admitted with parameters of the rules of evidence during the trial. All right, what else do we need to discuss today?
I don't think there's anything else to discuss.
I think we can just briefly, I saw that Ms. Perin wrote a letter because she knows that we're waiting for DNA results on the article of clothing of the victim. I only saw that letter this morning. I tried calling the lab, the analyst wasn't in, so I'll just keep everybody updated on that.
Okay,
And hopefully it won't be a problem, but I just wanted to just let the court know in case that it becomes a problem.
all right, so noted. And we do have the letter. I do have the information out from the DA as it relates to that DNA issue. And if we have to have a hearing prior to final pretrial to discuss it, we will, or we'll discuss it at final pretrial.
Actually, I have one more update. After I called, the crime lab called back and my secretary answered. They've done testing and they're in the process of writing the report, so we should have it soon. I don't know what the results of the report are yet based off of that note.
That's great.
All right, so then we should have information definitely prior to the final pretrial, which is set to occur on August 28th.
Then that should give me time to do what I need to do.
All right. Anything further that we need to address today?
Not from me.
No, thank you.
Okay, well then, thank you. We have our we have another status on August 12th, 2:15. I guess we can address any of the issues we have then, and then we have the final pretrial August 28th. All right, if there's nothing further, we are adjourned. Thank you.
Thank you.
Just, did the court say it did not want me to ask Corey to do the transcripts?
No, you can ask her. I can't guarantee she can do that.
That's all I had to ask.
Stacy Lundmark does a lot of them, so you can always reach out to her too. All right, then we are adjourned. Mr. Lemons, our next hearing is at 11, this Zoom.
Okay, I will be there. Thank you.